36, People versus Eric Iverson, and number 37, People versus Jack Cucceraldo. The attorney for the appellant will not be appearing for oral argument. He is submitting on his briefs. Counsel, we'll start with you and end with you.
So I'm the alpha and omega. All right. May it please the court. I was actually very excited when this case got granted leave because it's actually a very important case, and not for the usual importance that this court has, like, for example, Mr. Cohen and Mr. Zeno with right to counsel or First Amendment or anything like that. But this is an important case because this is the type of case that defines the justice system for most people in New York State. Because for most people, the only time they're going to have contact with the justice system, and more specifically the criminal justice system, is through a traffic ticket. So if they're not treated with honor and dignity and respect, it will color the way they feel about all of us. So that's why it is very important, this case, that their rights be scrupulously honored.
Counsel, what do you think that the Bureau should have done? Is it okay if they had the police officer testify as to what happened and what the charges were and why, and then grant a default? Is that permitted?
Well, I would certainly say that would present a much tougher case for me. Fortunately, they didn't do that. But even in that situation, under Parker, People v. Parker, which, obviously everybody knows, the hearing officer or the judge would have a burden to show, or at least make some finding as to why this individual didn't show, and it has to be an intentional failure to appear on a criminal case, as per Parker and Epps and those decisions. So, like I said, that would present a much, much more difficult case than this one. But
And counsel, regarding 1806A1, what's the effect of the legislature's omission of the district court from the listing of the local criminal courts?
actually, it was interesting because I was just talking to a village judge, Billy Wexler. And village courts and town courts, as I'm sure you're aware, meet infrequently. And Judge Wexler's court actually is on an island, on Fire Island, Ocean Beach. So sometimes the court shuts down for the winter. So that's really a normative regulatory rule setting up the timing for things. So I don't think, because district courts meet every day. So that's what I think that was meant to address.
Counselor, if on 1806A, do you think it's necessary to draw a distinction in cases where someone's appeared, entered a plea, let's say in this case, a plea to not guilty, and then fails to appear for trial, to a no-show, somebody doesn't show at all, a no-show initially?
Oh, you mean the failure to answer?
Right, failure to answer at all, you don't show up, there's a no-show. Do you think that 1806A is limited simply to the entry of a plea, because you could read it that way, or you could read it that it would apply to both situations, both a plea and a no-show at all?
Well, I think 1806A is set up for the situation where the individual gets the ticket and goes, you know what, they got me, or I don't have time to fight it. And that's really what it's set up for. And it specifically says failure to answer. And as we know...
So you would say it applies to a failure to answer in any form?
Correct. Correct.
see.
Just, like I said, it's for the person who says, you know what, they got me.
And what about the argument that that this is going to burden the system with an enormous number of bench warrants?
I've been doing this for 26 years. I don't think so. I honestly don't. I think it's a...
What's the basis for you, besides your personal experience, to say it wouldn't affect it?
You mean the vacate the defaults?
Yeah.
Like I said, it's, I think the system was, they had it in Cooper Street, this type of setup in Nassau County for decades, since the 1970s, and they've never had this issue before. It's, and Cooper Street didn't do the default conviction. What would happen in Cooper Street in Nassau County, if you don't show up for trial, they send you out a letter and say, we've rescheduled your trial, show up on this date, or, certain actions can be taken, and they list it all. And that's the problem as well here with 1806A. It says you have to have the 30-day notice, which they didn't do either. They just you know,
And
Mr.
and what
Iverson.
happens after the notice? Let's say they had done that, what happens after that, if the person doesn't show up again?
Then I believe they can probably do a default or
At that point, they do a default, or they proceed with the hearing?
I would say, my gut would be proceed with the hearing, but certainly an argument could be made for the former as well. But like I said, they didn't comply with any of 1806A, so, you know.
Well, normally you have the sheriff, the deputy, the officer is there. If the person doesn't show up, they default. You put them on the stand, you ask them 5 questions, and then you have a record for a conviction.
Right, but, you know.
That
like
would
I
be
said-
the normal process, right?
Like I said, well, if you do the Parker, you know, issue beforehand, then, you know, make sure there is a valid reason. Like, for example, Mr. Iverson ended up there late, you know, and showed up late, and they had already defaulted him. And Mr. Cucceraldo had some kind of personal issue which, you know, resulted in the default. So, you know, they didn't do anything. There was no testimony taken, no evidence given. They just-
Counsel, a good question.
Sure.
District court, just for me, does that cover one town?
No, it's actually in Suffolk, it's most of the county. It's most of western Suffolk. So I'm assuming you're from upstate.
Actually, I'm from Long Island, but fortunately
Oh,
never found my way into district court. But, so, there are certain towns, though, that don't have town courts, right?
Correct.
And
Mainly
those
the
are-
5 western towns.
And those are then covered by the district court? So
Correct.
There's 5, let's say, in Suffolk County.
Yeah, it's Babylon, Islip, Brookhaven, I'm going to forget something.
And so, going back to that last sentence of 1806A, couldn't you read that sentence to say, it doesn't say town court, it says court of such, the court of such city, village, or town. So isn't the court of such town, you could read that to be a district court, right? Where the town doesn't have a town court.
I mean, it certainly could be. It may very well be a legislative oversight.
But that wouldn't be an oversight. I mean, they didn't say town court, they just said court of such town, and where the
Correct.
town doesn't have a court, the court of such town is the district court, right?
I'm very angry I didn't think of that argument myself. That's very good. So, but yes, I
See
agree
that
with
Long Island
that.
roots, I guess, but yeah.
But yes, I do agree with that, so, you know, I read it as an oversight, but it may very well not be. But like I said, I think 1806A also shows why traffic infractions, the appellant made the argument that traffic infractions are just different, so that's why they can do this in this situation. But I think 1806A shows very specifically why they can't, because there had to be legislative carve-outs. And the items that he cites in his brief, right to counsel under 17030 and right to a jury trial under VTL 155, those are specific legislative carve-outs. There is no specific legislative carve-out for a default except CPL 620 for corporations and 1806A for failure to answer. So like I said, I think that argument, you know, the traffic infractions are different cuts against him because of the fact that I think it shows why they're not different, or why there has to be a legislative carve-out for them. So, unless anybody else has anything,
Thank you, counsel. Thank you
Thank
very
you.
much.